Hello, everyone. It's Michael Wright again today. I am the Modern Reformer. All right, today in this episode, we're going to be covering the idea that the common law is a double edged sword, and it truly is. First off, what is the common law? And where is there any reference to this, anyways? It is referenced in the U.S. Constitution, specifically, that's in the Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. All right. So what does that even mean? Okay, what is the common law? For a long time, the prevailing idea and definition of what the common law would have been is just law that is common to all man. That is not the case anymore, though, and the common law now, perhaps it would be more accurate to say that the understanding of what the common law is has increased over the last 100 years. But the common law is essentially law that makes the judges a legislator in the event that there is no law on the books for a specific matter. So let's say a gray area just comes up. There's nothing on the books for this specific subject. The judge now steps up and he gives his ruling, and his ruling is now law. Until the legislator comes along and passes a law, that judge's ruling is the law for everybody, and no one can change it either. It would every judge after that first judge's ruling would have to be made in accordance with his ruling. Like, he would lay the foundation and they could add on additional caveats, but that initial ruling for that gray area is the foundation at that point. So I bring this up because there's a lot of groups and things out there that always talk about the common law this, common law that, and they swear up and down by the common law, but I don't think they fully understand the dangers of common law in general. It is a double-edged sword, truly. And I'm not here to say it's good or evil, but we can't sit here and pretend like the common law is just the end-all be-all. Okay. If you we are a nation of laws, okay? So if you make it to where a judge can now create law, basically, you've made a mini dictator, a mini king. Mini, small. So really think about that. Think about how dangerous that is. How much power you're giving to one individual unilaterally. You know, we have the separation of powers in this country. The legislature for the states and the legislature, Congress, are supposed to make laws. Okay? So now you're having judges do the same thing as the legislators, but they're doing it completely by themselves. That is dangerous. That's a dangerous move. That's a dangerous recipe. So there are people out there pushing for and advocating for common law courts and whatnot. So I want you to really think about that. Would you really want to go to a court where the judge has just complete and total power? Would you really want that? There is no law on the books. It's the judge's just opinion. What if they don't like you? What if they don't like you? What if the judge doesn't like you? What's going to happen then? What if the judge just has a totally warped view in general and they got an agenda? What happens then? You see the dangers that this can impose? I would never want to go to a court like that. I want the universal standard of the letter of the law, not someone's opinion, not some judge's opinion. That's dangerous. So I just want to caution you guys about that. And I've referenced the common law, specifically the common law grand jury and the common law petit jury. And when I'm referencing those things, I'm really using that as more of a nickname for those two entities. Really, you could just call them the constitutional grand jury or the constitutional petit jury. Because at the end of the day, I'm only using that nickname in order to reinforce the point that our constitutional grand jury and petit jury are based on their English predecessors, their English progenitors. And that's a true statement, it is. And the English progenitor for those two respective entities did heavily rely on common law. No doubt about it. But think of it like this. We got to a point in this nation where, okay, our founders, they absolutely were under that system, and they were Englishmen, they were. And so they understood English law and English customs, and they brought that over. But think of it like this. They stopped, okay? They stopped. They kind of, I told you before that the trend would continue. You know, one judge would lay the foundation, and then each additional judge, if a similar matter came up, could stay with the same exact ruling, or they could add on caveats, so on and so forth, and they could just keep going further and further down the rabbit hole with caveats to that initial ruling. Well, even though our constitutional grand jury and petit jury are based on the common law, because the founders are not necessarily subjecting it to the common law, now it's constitutional law, the buck kind of stops, if you will. So that possibility to add on caveats and interpret based on your own opinion and so on and so forth, that's not a thing anymore. That's not a thing, because this is for these two entities specifically. That's why I use those nicknames, but I always clarify as well. It's like, hey, I'm just talking about the constitutional grand jury or the constitutional petit jury. I'm not necessarily advocating for the common law, nor am I saying that our U.S. Constitution is subject to the common law. Yes, the U.S. Constitution recognizes common law in this nation, but that does not mean that the U.S. Constitution is common law. Because think about it. If you were to say that the U.S. Constitution is common law, you would say that the whole U.S. Constitution is subject to the idea that these judges could sit there and just totally wing it. They could just wing it. Wing it when it comes to the Constitution. Wing it when it comes to your rights. And they could just add on caveat after caveat after caveat, and they would have no basis for it. It's just totally their opinion. Do you really want that to happen to the Constitution? Do you really want to potentially allow corrupt people to just destroy your rights? So that's why it's dangerous to just sit there and assume immediately anything with the word or the phrase common law in front of it is good. We have to be smarter than that, and we have to be more shrewd than that. Do not sit there and just go along with anything simply because it says common law. Not all things common law are great, but the common law grand jury, that's the nickname, that's another alias, is nothing more than the constitutional grand jury. And like I said, same thing for the petit jury. So those two things are okay, but beyond that, I really don't move forward with anything common law. And I'm not the only one who felt this way in the 1800s, because again, there were probably a lot more gray areas at that point in time because they didn't have as many laws on the books and whatnot. So there were probably a lot more gray areas to deal with. And there were a lot of individuals who were activists, and specifically they were trying to get things codified by the legislature so that these judges, so that the people wouldn't just be subject to the opinions of a judge anytime they hit these gray areas. And I agree, I wouldn't want there to be that much room for these judges to unilaterally act either. That's not how we intended or designed this nation. This nation was intended to have separation of powers, and the founders made sure that the legislature, Congress, and state legislatures are the ones who handle laws, passing of laws. The judicial branch is not supposed to fulfill that role. So yeah, we should, even though the U.S. Constitution says there is common law in the Seventh Amendment, we should make sure it is as small of a small percentage of cases and opportunities that could possibly fall under common law, so that we don't allow rogue judges to just start running wild and doing whatever they want. It's dangerous. So anyways, I hope that sheds some light on it. Like I said, summarized, I'm okay with the common law grand jury, common law petit jury, only because they fall under, I mean, again, they're just the constitutional grand jury and the constitutional petit jury. But anything else, trying to subject the Constitution to the common law or say that the Constitution falls under common law, I'm not for that. Trying to go to a court where judges' law or a judge's opinion is now the law for the whole area. Oh no, I'm not for that. Nope. I'm against that. It's dangerous, man. So anyways, I hope that was helpful. I hope it was informative. And if there's any questions, let me know. Leave your thoughts in the comments. And please like, share, subscribe, follow, whatever. If you thought it was informative and a valuable video. And with that being said, remember, I'm not a lawyer. I'm not a legal advisor. I'm not a legal consultant. I'm not a financial advisor. I'm not any sort of professional advisor or coach or anything along those lines. I make these videos purely for my own entertainment and my own fun. Do not misrepresent me. Okay. With that being said, Modern Reformer out. One more thing real quick. So I'm aware that the Constitution obviously says in the Seventh Amendment, common law is a thing. And even common law is, in regards to common law courts, certainly that's not the ideal situation I would want to be in. Not by any means, but I recognize why it's in the Constitution. Number one, like I said before, in the early days, there were a lot of gray areas. And the truth is, there may always be gray areas. And you need a way to deal with those gray areas where there is no law on the books. And this provides you that solution. I get it. So it's not that I think the common law is evil or anything like that. It's just I would rather be under the letter of the law as opposed to someone's opinion. Nonetheless, I acknowledge it is a necessity. There is a need for it still. Just it should not be the prevailing situation, if you will, or the prevailing type of suit. Not by any means. Anyways, that's all I wanted to say.